Hello, and welcome to another Hub 101. My name is Imani Moore, and I'm the engagement coordinator for the Austin Community Hub.
Hi, I'm Zenobia, and I'm the Community Resource Coordinator for the Austin Community Hub.
Yes, and I want to go ahead and start by introducing a little bit about who we are and what we do, if you didn't know. The Austin Community Hub was designed to be a dedicated space where we can engage with the members of our community. So we're here to serve as a connection between Austin residents and all the services that are offered by ACT's network of partners, organizations such as childcare, job training, youth programs, legal assistance, and much more.
Each one of our Hub 101s gives you all an opportunity to get to know our different partners and get live answers to your questions. Hub 101s take place twice a month on Zoom and Facebook Live.
Yep. And today we are joined by Caitlin Cutshaw and Eddie Martinford from the Law Center for Better Housing to talk to us about all the work that they do. We'll end with a Q&A session shortly after the presentation. So feel free to drop any questions that you have in the Q&A box on Zoom, or if you're watching from Facebook Live, please don't hesitate to drop those questions in the chat. And right after the presentation, we'll start to answer those for you. And yeah, thank you so much. Without any further ado, Caitlin and Eddie, the floor is yours.
Awesome. Thanks so much, Amani, and thanks to the Austin Coming Together community. I'm going to go ahead and pull up our slides and get into a quick introduction of Eddie and myself. So my name is Caitlin Cutshaw. I'm an attorney, staff attorney, and pro bono coordinator with Law Center for Better Housing.
And hi, everyone. My name is Eddie Martinford. I'm an attorney with the Law Center for Better Housing as well.
Awesome. So thanks, everyone, for joining us. Welcome to Tenants' Rights 101, your guide to renters' rights and the eviction process. So just to give you a little bit of additional background on Law Center for Better Housing, we do provide free legal and supportive services to low to middle income renters in the Chicago community. We do exclusively serve tenants in the private market since there is a lot of legal aid resources for tenants in subsidized housing. We sort of fill this gap in services for tenants in the private market. And our goal is that all renters in Chicago have a safe, decent, and affordable place to call home. So aside from legal services, we do also do outreach like we're doing today in getting connected with the community and making sure folks are informed of their legal rights. We do also some policy advocacy at the state and local level. We have an online tenant chatbot that serves renters called Rentervention that we'll talk a little bit more throughout this presentation on how you can access. And then we also do pro bono programs like clinics in the community. And we have one in the West Side coming up here in June, which I'll mention towards the end. So the goal for this presentation is to inform you about your rights as a tenant, to give you an overview of what to expect in eviction court, and to provide you with resources to find help if you have housing issues. And this is geared more towards tenants, but if there are advocates joining us, certainly there's good information in here for you to share back to community members that you serve. So just as a heads up before we jump in, we're going to go through asking some questions or myths that we have come across in serving renters. And these questions are not necessarily for you to, you don't need to, put your responses in the chat or anything like that, but just take a moment to think about them in your head, and then we'll sort of follow up with what our understanding of the truth, so to speak, behind these myths. So the first sort of question that we pose is, the Chicago Residential Landlord and Tenant Ordinance covers every rental property in Chicago. And surprisingly, this is fiction. This is false, in other words. So backing up here a little bit, what is the RLTO? The RLTO, for short, for long, is called the Residential Landlord Tenant Ordinance. There are versions of these in different municipalities across the state. Chicago has its own. Cook County has its own. Oak Park, west of the Austin community, has its own. But we're going to focus specifically on the Chicago RLTO in this presentation. So basically, it governs the rights and duties of landlords and tenants in residential buildings in Chicago. So it applies to most rental units in the city, but there is a what we often call mom and pop exception in the ordinance, which basically means that if the landlord lives in the building and there are 6 units or fewer, the RLTO does not apply. So, in other words, if your landlord does not live in your building, you're likely covered by the RLTO. If your landlord does live in your building, it might be a good idea to get an idea of how many units are in your building in total. If there are 6 units or less, you are likely not covered by the RLTO. That said, there are exceptions to the exception in that 2 provisions in the RLTO do apply to every single unit in Chicago, namely the lockout provision and provisions governing notices of non-renewal and rent increases, which we will talk about a little bit later in the presentation. So to start off, we're going to talk about what are some things that should be included in your lease according to the RLTO and some things that should not be included in your lease. So we're not going to go through every single one of these in detail, but to highlight a few, most leases should include a copy of the RLTO, a summary of your rights attached to the end of it, which is helpful for tenants who may not, understand all of the provisions that are included in the RLTO. So keep an eye out for that when you're entering into a new lease. Leases should identify or notify you of the owner's address and phone number. Obviously, this is essential, especially in terms of contacting someone for repairs or just everyday sort of things that come up as you're a tenant in the building. Additionally, you should be given information on the bed bug ordinance and your obligations under that, which we'll talk a little bit about in this presentation as well. And then something that comes up from time to time too is being aware or notified of if there are pending building cases or code violations or citations on the part of the landlord that have occurred in the past 12 months. Obviously, something that is great to be aware of when you're entering into a lease or taking on a new rental unit, but also required under the RLTO. Couple things that should not be included in your lease and to keep an eye out for are clauses that require tenants to waive certain rights. So to highlight a few, being required to waive your right to a jury trial, being required to waive your right to notice of termination or a specific notice period, or clauses that limit the liability of the landlord or tenant, or in other words, if there was a lawsuit or claim to arise from the tenancy relationship, a limitation of liability would basically limit the amount of damages that you could seek. These are prohibited. Additionally, clauses that require the tenant to pay the landlord's attorney's fees, and we'll learn a little bit more in the second half of this presentation, which Eddie's going to take over, that attorney's fees cannot be sought in an eviction case. But they should also not be included in a lease term that you're required to pay your landlord's attorney's fees. Additionally, one that comes up quite a bit is late fees. So a landlord can only charge a certain amount of late fees in the lease. Basically, what it says on the RLTO is that a landlord can charge $10 for the first $500 of rent and then 5% on any amount above $500. So for example, if your rent is $1,500, that would be $10 for the first 500 and then 5% on the remaining 1,000, which would be $50. So your total late fee would be $60 at most. The landlord could not exceed that amount for a late fee. One quick note here, if a landlord does attempt to enforce an unenforceable lease provision, they may be subject to liability of 2 months rent. So you may have a potential claim or lawsuit there. Most often though, if you do see one of these lease terms that should not be included in your lease, they are unenforceable. So they oftentimes you might see them and it might cause you concern at first, but there's really no action until a landlord attempts to enforce those unenforceable lease provisions. So to talk quickly about security deposits, there are very strict rules in the RLTO concerning security deposits. If your lease does require a security deposit, your landlord must provide you with a receipt that includes the amount, the name of the person receiving the deposit, the date, the address for the rental unit, and it must be signed as well. Also, the landlord is required to notify you of the name and address of the bank where the deposit will be held. Oftentimes, this is going to be on the face of the lease. If you do not have a written lease, if you have such, for example, an oral lease agreement with your landlord, which I did forget to mention on the last slide, oral lease agreements are normal and valid in Chicago. If you have an oral lease agreement, your landlord should still provide you written notice of the financial institution holding your security deposit. So for Chicago only, uh, your landlord should also be paying interest to you that accrues on a security deposit. Interest is only going to be paid if the security deposit is held for more than 6 months. Uh, if it is held for longer than that period of time, then the landlord would be paying you interest every year at the end of every 12-month rental period. The current interest rate, and these are published every year by the city of Chicago, is 0.01%. So you shouldn't be anticipating quite a bit of interest being paid on your deposit. When you move out, a landlord is required to return your deposit within 45 days of moving. It's a little bit different in different municipal ordinances. So, for example, if you live, across the way in Oak Park, I believe it's 30 days that the landlord is required to return your security deposit. So just keep an eye on the different sort of ordinances because the time frames do differ a little bit from place to place. One thing that's not included in this slide is, and this is a question that often comes up, is can a landlord deduct certain amounts from a security deposit? And the answer is yes. A landlord can deduct unpaid rent from a security deposit that was not lawfully withheld. And a landlord can also deduct a reasonable amount necessary to repair any damage caused by the tenant. However, if they do plan to deduct, there is a strict process that they should go about. They do need to provide the tenant with an itemized statement of damages within 30 days and should be presenting paid receipts as well for any amounts of repairs that were paid for and deducted from the deposit. There are very strict penalties for landlords who do not follow the very strict security deposit rules, and that if there is a violation found, a landlord may be liable for damages in the amount of 2 times the security deposit, as well as attorney fees. And if they did not return a deposit, if that's the violation that they would have committed, the tenant obviously can also seek return of the deposit. Last note here, move-in fees are not security deposits. Keep an eye out on communications with your landlord or in a lease. We have seen before landlords indicating move-in fees as refundable. If a payment is refundable, it is possible that it could arguably be considered a security deposit and subject to those more strict rules. So to run through some responsibilities on the part of the tenant, as we know, there are lots of responsibilities on the part of the landlord, and as a tenant, there are some to keep in mind as well. First and foremost, ensuring that you're paying your rent on time. In terms of some advice that we provide tenants around this, oftentimes it's best to be paying by check or money order, or electronically as well, but I have a note on that in a moment. But cash can be a little bit difficult since we're not oftentimes able to keep as good of records of that. If you are paying in cash, or even if you're paying with check or money order, you should always be requesting a rent receipt and keeping really, really good records of all of your payments and all of your rent receipts received by the landlords. There was a new law passed in Illinois not too long ago saying that landlords cannot require electronic funds transfers electronic fund transfers as the method of payment. They can still use it, and you can still, if that's your preferred method, you can still use that with your landlord if that is allowed as part of the lease agreement. It just cannot be the sole form of payment that the landlord is requiring. If you cannot pay your rent or having difficulties or may have fallen behind because of financial hardship, personal hardship, whatever it might be, we do recommend communicating with your landlord early and often, maybe negotiating a payment plan. If a payment plan is negotiated, that's important to get in writing, and make sure everybody's following through on their obligations under that. And also, it can be helpful to contact any social services organizations for rental assistance. I think one of the quickest and easiest ways to get connected with rental assistance in Chicago is to call 311. And they can direct you to either community centers that might be processing rental assistance applications or other community-based organizations that provide rental assistance. In terms of communicating with your landlord, we use the word dealing here. It can be a difficult relationship sometimes, hopefully not. But if your landlord is being unresponsive, it's always a good idea to keep communications in writing and keep copies and records of every, conversation. Text message and email is going to be great for having a good record of communications, but oftentimes we have tenants whose landlords come to the property to make repairs, and conversations are had, or we have tenants who have landlords who only communicate by phone calls. My advice is keeping a really good record as close in time as possible to when an oral or verbal communication has happened. Write it down right away, just so you have record of what was discussed, especially if it's important information. And when we go through some of the additional provisions in the RLTO a little bit later in this presentation, we're going to highlight oftentimes some of these things can be difficult to prove. So if an issue does come up with your landlord, if you feel like they have violated a provision in some way, if you've kept really, really good records of your communications with the landlord throughout your tenancy, even if you didn't think it was going to be an issue later, you're going to be in the best position possible to defend yourself or to present a claim against the landlord. So just to run through the rest of these, bed bugs, there are specific obligations under the bed bug ordinance. If you have a suspicion of bed bugs, it's important to report those in writing within 5 days of discovering them. Important to maintain your apartment and protect it from damage. This does also apply to any guests you may have in the unit. And then notifying your landlord frequently about routine maintenance. And then finally, upon moving out, make sure you're in communication with your landlord. It's great to do a sort of walkthrough, take pictures, and record anything, any normal wear and tear that may have come up throughout your course of living in the unit. And then removing all property, trash, and debris on your way out. So another myth that we're going to pose here is if a tenant has problems with the conditions in their apartment, they can withhold all of their rent. This is actually fiction or false, and something that comes up from time and time again. It's important not to withhold all of your rent, and we'll see why on this slide. So the landlord does have a duty to maintain the premises in compliance with the municipal code and the rental agreement, and is required to promptly make any and all necessary repairs. Generally, we advise tenants to go through this. Actually, I'm going to back up. We generally advise tenants to go through sort of the standard process of requesting repairs first, whether that is using your renter portal to request a repair to put in a work order, or calling the landlord, or sending a text message or an email, whatever the sort of normal method is. If the landlord is then unresponsive to your repair request, you do have some additional rights or ways that you can follow up under the RLTO. So what if the landlord is non-responsive to your request for repairs? You can send a letter, written notice to the landlord demanding the specific repairs you want made, and if they are not repaired within 14 days, you can exercise your rights under the RLTO, which includes terminating the tenancy, making the repairs yourself and deducting that amount from your monthly rent, and then finally withholding. So just to touch on each of these remedies specifically. Um, First and foremost, you should not be taking action until the 14-day notice period has ended. So if you serve this 14-day letter on your landlord, you should be counting from the date that they receive it. And this is why we usually advise that tenants serve these letters in the best, in a way that they can confirm that the landlord received it. And that can be by email and requesting that they confirm receipt in their email response. That can be by certified mail with tracking and a return receipt. Or that can be personally delivering it to the landlord, maybe with a witness present, so you have extra sort of confirmation that the landlord got it. Wait the 14 days from the landlord receiving it. If the repairs are not made or not fully and sufficiently addressed, you can exercise your rights from there. So terminating your tenancy is one option. Generally, we advise this for more severe conditions. If you do exercise this remedy, after you notify the landlord of your intent to terminate the tenancy, you have 30 days to move out. If you don't then move out for whatever reason, then your notice is deemed withdrawn, and your lease is going to continue just sort of along the normal lease obligations that you have, and that would include continuing paying your rental obligation going forward. So another option is to make the repairs yourself and deduct that cost from your rent after providing paid receipts. Just want to note that this option is only available when the cost of repair does not exceed $500 or one half of your rent, whichever is greater. So these are generally going to be kind of more minor repairs. And then finally, withholding. So the ordinance specifically says that a tenant can withhold an amount that reasonably reflects the reduced value of the premises. That is a pretty broad statement. It's difficult to define, but we are always advising tenants to be conservative and do not withhold more than half of your rent, just to put you in the safest position possible. Um, so, your process for exercising your rights for essential services under the ordinance is a little bit different. So, with essential services, we're referring to heat, hot water, electricity, gas. And if you have an issue with one of these services going out, first and foremost, call 311. Make sure that you're reporting the issue to the Department of Buildings, so they're a little bit more serious and severe. And you can also similarly, you can send written notice to the landlord requesting that the issue be resolved immediately. And if it is not, there are certain rights that you can follow through with. So some of these include getting reasonable amounts of replacement services of heat, water, electricity, gas, etc., and presenting the landlord with paid receipts. So, for example, we'll sometimes have tenants if their heat service has gone out, they may seek or purchase some, safe space heaters for their unit and present the paid receipts to their landlord and deduct that cost from their rent. They may also be able to seek damages in, a legal action against the landlord, and they may also seek substitute housing. So, in terms of seeking substitute housing, for the period of time that you are displaced from the unit and in substitute housing, you're released from the obligation of paying rent. But you can only recover the cost of the substitute housing up to 1 month's rent, or if it's less than 1 month, prorated for that period of time that you were displaced from the unit. In addition to those three remedies, you can also consider two additional steps. So, if the issue is not resolved within 24 hours, you may withhold, again, an amount that reasonably reflects the reduced value of the premises from your monthly rent. Or you can, if the issue is still not resolved within 72 hours, you can move forward with terminating your lease. So another myth here. The amount of time a landlord must give notice before a rent increase is based on how long the tenant has lived there. This is actually true. So thanks to some recent changes in the ordinance, a landlord is required to give a certain amount of notice based on how long a tenant has lived in the unit. So this obligation applies to notices of non-renewal and notices of rent increase. So if a tenant has lived in the unit for 6 months, they are entitled to 30 days notice. If they've lived in the unit for more than 6 months but less than 3 years, they're entitled to 60 days notice. And if a tenant has lived in the unit for more than 3 years, they are entitled to 120-day notice. So to provide sort of an example of this, let's say if you've lived in your unit for 4 years. Let's say that your landlord gives you a 30-day notice that they're not going to be renewing your lease and that you'll be terminated thereafter, and you have to move out. You can actually So the remedy that is allowed in the ordinance is it says that you can remain in the unit for the amount of time that you're entitled to notice under the ordinance. So in that scenario, you would be able to remain in the unit for 120 days after the date you receive this insufficient 30-day notice. And your rental obligations and lease terms are going to remain the same for that period, for that notice period. So for rent increases, for example, if a landlord gave you notice of rent increase but didn't give you the right amount of time before it's supposed to kick in, you can, based on how long you've lived in the unit, you will continue paying your normal rent amount for the period of notice that you're entitled to. And then once that expires, you will unfortunately be obligated to pay the rent increase. So quick reminder, the fair notice requirements, this is what we refer to as the fair notice requirements. They apply to every every unit in the city of Chicago. So they are accepted from that mom and pop restriction. So another myth, a landlord cannot turn off the water if a tenant a landlord cannot turn off the water if a tenant falls behind in rent. This is true. So, this is what we would generally refer to as an illegal lockout. Um, a lockout is where a landlord or their agent knowingly ousts or dispossesses a tenant from the unit or threatens or attempts to remove the tenant from the unit. So the following actions can be considered lockout by the landlord if done intentionally to get a tenant out. And this includes changing the locks, plugging the locks, removing doors, removing windows, shutting off utilities, removing personal property, generally making the apartment uninhabitable, such as by turning off utilities, which I had mentioned just a second ago. So similarly, the lockout provision does apply to every unit in the city of Chicago. So some steps to follow if you're locked out. First and foremost, call the police. I understand and acknowledge and respect that this is not the best option for many renters. That said, the police are required to respond to illegal lockout situations under a special order, which is noticed here, or which is included here. Sometimes police will show up on the scene and say that it is a civil issue and not a criminal issue. They can't get involved, or they might say that they can't do anything unless the landlord is there. Reminding the police of your understanding of their requirements and their special order, it can be important. But most importantly, requesting an incident report or a police report. So ultimately, if the police aren't going to be taking any sort of action on site, requesting an incident report can be good to have that record of the lockout having happened. Or if you have the ability, go to the local precinct and get the full police report. So the incident report is usually sort of that one sheet of paper they'll give you on site. The police report is going to have a much more detailed record of the responding officer, their notes, and things like that. In some cases, you may be able to request arrest warrant be put out for the landlord. That's going to be probably a more extreme situation. It doesn't happen often. But finally, after taking those steps, you may be able to seek help from an office like LCBH or another legal aid provider that does help with lockouts. And the one thing I did forget to mention is keeping record of your tenancy with you can be important because When people are responding to these lockout scenes, they might not have an understanding of who's who in the landlord-tenant relationship. So if you have a record of like your utility bills on your phone, pulling them from your utility account, being able to show that you're a tenant in the building, or having a copy of your lease available. Although not all of us are walking around with a copy of our lease, but if you have it saved on your phone or something, that can be helpful. If a tenant calls the city to complain about conditions issues, the landlord can terminate their lease. So this is false. This is fiction. This is generally what we would refer to as retaliatory conduct on the part of the landlord. So retaliation is prohibited under the RLTO. It is illegal for a landlord to knowingly terminate a tenancy, increase rent, decrease services, bring or threaten to bring a lawsuit against the tenant for possession or refuse to renew their lease. If the tenant has complained to a government agency, requested repairs, joined a tenants union, or engaged in other protected conduct. So there is a new Illinois state law that brings the RLTO retaliation provisions to apply statewide, essentially. And if a landlord does act in violation of this section, under the local ordinance and under state law, the tenant does have a defense in any retaliatory action. The landlord may be subject to damages. The tenant can terminate the rental agreement or recover possession, get back in the unit if they've been dispossessed, and they may be able to recover an amount equal to 2 times rent plus attorney's fees. So it's important to note that retaliation is very hard to prove. This is why, as I noted at the earlier slide, it's really, really, really important to keep good records. It is also rebuttable, meaning that if the landlord can prove a legitimate non-retaliatory basis for the adverse action that they took, they may be able to rebut the defense of retaliation. Timing and evidence are going to be really, really important here. So being able to show that the tenant took protected conduct prior to the landlord taking adverse action, and then having some evidence of that and making sure it's well documented. So before I hand it over to Eddie, I just wanted to talk about LCBH's online tenant chatbot called Rentervention, which I mentioned at the outset of this presentation. Many of the issues that we just walked through, retaliation, fair notice ordinance, prohibited lease terms, can be helped by reaching out to Rentervention. So Rentervention is a AI-supported chatbot. Tenants can get connected by texting hi to this number here, 866-7-RENTER. We'll also, at the end of this presentation, show you where our website is, and that you can also access Rentervention through our website. If you can get, self-help tools, answers to all your questions, but if the issue is a little bit more complex and you feel like you need additional legal services, you can request to be put in a virtual clinic that is staffed by LCBH attorneys and attorney volunteers. So yeah, and with that, I'm going to hand it over to Eddie to talk about the eviction process.
All right. Thank you so much, Caitlin. So like I said, everyone, my name is Eddie Martinford. I'm an attorney at LCBH as well, and I'm one of several attorneys who works with the Early Resolution Program to provide free legal advice to tenants who have just had their first court date in eviction court. So now the next part of our presentation is going to focus on an overview of the eviction court process and kind of everything that's involved from start to finish with going through an eviction case. So here are kind of the general steps of what happens as you go through an eviction case. So you have to start out by getting a termination notice, which Caitlin touched a little bit on earlier. So that non-renewal notice that she was talking about is an example of a potential termination notice that lets you know that your landlord's requesting possession back. You could also get a termination notice for failure to pay rent or for some other kind of breach of the lease. We'll go over each of the different kind of options in a minute. But first, you receive that notice, which gives you some time to either remedy whatever the issue is or vacate your unit. If you do not remedy the issue or vacate the unit by the deadline, then your landlord would be entitled to file a case. So that moves us on to step two here. Once they file a case, they have to give you a summons. This is a document that tells you that you have been sued and requests that you attend court. It provides information to you about how to attend your court date, and it can be served in a variety of different means. Again, we'll get into that a little bit later. Once you have a copy of the summons and are informed of your court dates, your next step would be to go to court. Um, at court, tenants in Chicago and Cook County, like I said, are referred to the early resolution program where they are provided free legal advice. Once they've gotten that free legal advice, their case moves on eventually towards a trial. During the trial, a judgment is made. If an eviction order is entered, then we move on to this last step here, which is enforcement, and that is where the sheriff would come out to enforce the final eviction order after a judge has ruled that the tenant ought to be evicted. So taking a little bit closer look at the termination notice, termination notices can be broken down into either a for cause or no cause termination notice. What Caitlin was talking about earlier, that 30, 60, or 120-day notice, those are no cause notices, which means there was no kind of breach of the lease, there's no issue with non-payment. The landlord is just requesting that their property be turned back over to them and then they be granted possession. Now, for cause termination notices are for when there is some kind of breach of the lease or non-payment of rent issues. So if a tenant falls behind on rent, then they would be entitled to at least 5 days notice in the termination notice. So they would have 5 days to either pay off the rent that's owed or vacate the unit before the landlord would be entitled to file an eviction case. If they don't pay the rent or vacate the unit, then the landlord would be entitled to file a case at the expiration of those 5 days. The other option is a 10-day notice. This is for when the tenant violates a lease term. So there are all kinds of different ways, a lease term could be violated. One common example is if the lease says you're not allowed to have any pets and the tenant gets a dog, then the landlord could provide the tenant with a 10-day notice that says you either need to rehome the dog or you need to move out within 10 days. And if the tenant doesn't cure that breach, then again, the landlord would be entitled to file an eviction case. And then, yeah, no cause notices, kind of like we covered, provide different amount of time depending on how long the tenant has lived there. And as Caitlin touched on, can be retaliatory. All right, so quick fact or fiction question. The eviction court can only enter an order against a tenant if they get the court summons in their hand from the sheriff. And this is fiction. So the sheriff is one of the more common ways, and usually the first way a landlord will try to serve a summons, but they have other options for how they can try to serve the summons as well. If the sheriff is unable to reach the tenant, they could also have the notice served by what's called a special process server. This is someone who their job is to serve these summons on people. And they can oftentimes appear at people's homes in plain clothing with a copy of the summons. So just because someone receives a summons from someone who is not a sheriff's officer doesn't mean that summons is necessarily invalid. They may also serve the summons by posting it. This involves putting the summons in a couple of different public places, as well as mailing a copy to the tenant. The public places that it has to be posted to are the courthouse, city hall, and a few other locations. I've never heard of someone actually seeing a notice be posted in a public place. They almost always receive it in the mail, and that's how they know that they are being sued. All right, so another fact or fiction question. A tenant must file paperwork before they go to court on their first court date. And this one is fiction as well. So tenants aren't required to file anything before they go to court, and that could be a little confusing sometimes because the summons sometimes has directions on it that says the tenant must file an appearance in order to participate in their case. But because of the early resolution program and the way the courts are established in Chicago, tenants are able to attend their first court date and get connected with an attorney who will provide them free legal advice before they have to make any decisions about filing something in their case. So we always recommend people attend that first court date, get connected with an attorney, and if they have questions about filing anything, ask the attorney and see what the attorney thinks about filing anything into the case. There are rare circumstances where a tenant may not want to file any appearances into the case. And to make sure that those don't apply to you, it's always better to meet with an attorney first to see what they think. All right, next question here. Once an eviction case is filed, it is too late for the tenant to get help. So this one is definitely fiction. The early resolution program obviously kicks in after someone has had an eviction case filed against them, and that's where the tenant is entitled to get free legal advice. So that is a great way for people to get connected with help through the early resolution program. Those attorneys can advise people about potential defenses they have, can advise them about potential settlements, and even in some cases help people try to negotiate a resolution. They also are able to get connected with the court-based rental assistance program after the case is filed, which is another great help to tenants to help pay off back balances if the issue that's causing the eviction case is non-payment of rent. And of course, there's also mediation services available through the early resolution program to help people reach an agreement. So as far as the court dates go, after you've gotten that summons, you'll go to your first court date, which is set for a status. During that court date, it will be very brief. The judge will just get the tenant connected with the early resolution program, and the case will be continued for 14 to 28 days. That's usually much closer to that 28 days. Sometimes it's even longer than that. That gives time for the tenant to be connected with an attorney. Sometimes people are able to talk to an attorney right after they go to that first court date, but most of the time they have an appointment scheduled for some time later. So the tenant's case will be continued for about 4 weeks, and maybe they meet with an attorney to receive advice during week 2 or week 3 before they come back to court. Now, one thing to be very conscious of if someone is facing a potential eviction case is that if the tenant does not go to their first or second court date, the judge could enter a default eviction order against them. This means they would enter an eviction order just because the tenant is not there. And that, of course, would be enforceable by the sheriff's office, which means the whole process would be sped up significantly because they'd be getting an eviction order very early. So even if a tenant is very confident that they don't have any defenses or don't think they have any way to resolve their case, it's still very important to attend all court dates. That way, an eviction order is not entered any earlier than it could be had the tenant been there. Now, after your first court date or a tenant's first court date, that second ERP court date, the parties will come back to court. The judge will see if they've reached some kind of agreement or settlement to the case. If not, the case will be transferred to a trial courtroom. Those transfers usually take 2 to 3 weeks. The judge in the ERP courtroom will provide information to the tenant about how to learn about their next court date after the second ERP status date. Once in the trial courtroom, the trial judge will have another opportunity for tenants to enter an agreement with the landlord, with the court, if they've reached some kind of agreement during that transfer period. Otherwise, the case will usually be set for trial another 2 or 3 weeks after that first time in the trial courtroom. So all in all, it takes about 2 months from when the case is when the tenant originally receives their first court date to when the case goes to a trial. Of course, it can wildly depend on the court's schedule and what courtroom the tenant is for how much time they receive. 2 months is certainly on the shorter end from that first court date, but generally speaking, that's about how much time people get before their case ends up going to a trial. Now, an interesting thing, if a tenant is in court because of non-payment of rent, tenants have what's called the right to cure if their unit is covered by the Residential Landlord-Tenant Ordinance. The right to cure is the right to pay off all the rent that is owed, plus the landlord's court costs and filing fees, in order to force the landlord to dismiss the case and allow the tenant to stay in the unit. Now, this right is limited to the city and suburban areas minus Evanston and Mount Prospect. Evanston and Mount Prospect have their own ordinances that apply separately to those areas. They are not covered by the Chicago Residential Landlord Tenant Ordinance, or they are slightly different from the Cook County Residential Tenant Landlord Ordinance. It's important to keep in mind the right to cure is a one-time right. So if someone finds themselves in eviction court for a non-payment issue, and they use rental assistance or their own money to pay off everything that's owed, plus those court costs and filing fees. And then they fall behind on rent again sometime in the future. They have already exercised their one-time right to cure in that previous case and may not have the ability to do so again. Of course, they're always free to work out an agreement with the landlord or the landlord's attorney, but they can't force the landlord to take all the money that's owed and dismiss the case if they have done that in the past. Now, as for what kind of legal aid options are available to people. So first, like I said, everyone gets connected to the early resolution program to provide free resources to people. So you would meet with an attorney in a Zoom breakout room who can give you advice about any defenses or settlement options you have, answer any questions you have about the eviction case, and get you connected with other resources such as the court-based rental assistance program, which can help people cover back balances if they're behind on rent. And they can also refer people to mediation, so you can discuss your eviction case with a neutral mediator who would be able to help kind of bridge the gap between the landlord and the tenant and try to reach a resolution in the case. This program is administered by a combination of a couple of different organizations, so there's no guarantee that you would be referred to the Law Center for Better Housing. Subsidized tenants usually go to Legal Aid Chicago, so this is kind of an amalgamation of legal aid organizations that are all under one umbrella, which is that Cook County Legal Aid for Housing and Debt. Now, ERP, the Early Resolution Program, has changed some things about how that initial court date is going to function. So first, the case has to have its first court date at least 30 days after the case was filed, and that first court date has to be a status date or an initial case management date, where if the tenant is there, they get connected with the Early Resolution Program, and that's why they get that 4-week continuance to make sure that they have time to get connected with an ERP attorney and provided that free advice. Now to talk a little bit more about the court-based rental assistance program. So this is a program that is run by the Illinois Housing Development Authority that assists people in paying off back rent if they have an eviction case for non-payment of rent. It is only available to people who are currently in eviction court. They do have some programs that I believe can help tenants pay for rent at a future place, but in order to receive unpaid rent at your current unit, you must have an active eviction case against you. The program requires the tenant and the landlord both submit an application to be eligible for receiving the assistance, and that assistance can pay for up to $15,000 in unpaid rent, as well as up to 2 months future rent. Now, a little bit of a caution here. The program is coming to the end of its funding cycle at the end of this month, so some things may change as it moves on to a new funding cycle next month. So some of the information I'm providing may be subject to a little bit of change, but they are open right now and they are accepting applications. So if there are any tenants who are currently in eviction court as of May 2025, the sooner you apply to this program and let the landlord know you've applied, the better. And if a tenant sees themselves in eviction court sometime after this month, going to their website and taking a look on if they're still accepting application will be the best way to figure out if this is still a good option. All right, another fact or fiction question. If a tenant cannot afford the court fees, the tenant can ask the court for a fee waiver. So this is fact, but sort of. So if a tenant needs to make their own filings, for example, we very commonly recommend that tenants file an appearance and a jury demand so that they can have a trial by jury. Those filings will cost about $250, and they can also file a fee waiver asking the court to waive those costs if they have limited income and aren't able to afford the cost of filing those things. So this is true that the tenant can get their own court costs and filing fees waived, but the tenant cannot waive their landlord's court costs and filing fees. So if a tenant is in eviction court for non-payment of rent and they want to exercise their right to cure, their right to cure requires the tenant to pay their landlord's court costs and filing fees. Those are usually about $500 to $600. And even if they file a fee waiver and that fee waiver is granted, they are still going to have to pay that $500 to $600 in the landlord's court costs and filing fees. So that's why this one is partially true. I want to make it clear that you can waive your own fees, but you can't waive somebody else's fees. All right, and then the last step of the eviction process is, of course, what happens at and after trial. So, if the case makes it all the way to trial without any kind of resolution being reached, then the judge will enter a final order. Obviously, if the tenant wins the case, then that would be when the case is dismissed and no eviction order would be entered. The tenant could then ask for the file to be sealed so it's no longer showing up on the public court record. We'll talk a little bit more about that in a moment. But more often than not, the way a case would end if it does go all the way to trial is that an eviction order would be entered. Once an eviction order is entered, the judge can decide whether or not to stay the enforcement of the eviction. That just means to put a pause on the amount of time before the landlord can give the eviction order over to the sheriff's office to enforce it. So if the judge puts in a stay, that's a little bit of extra time where the tenant knows that the sheriff's office won't be out because they have to wait till the end of the stay to give the eviction over to the sheriff. Now, even if the eviction order is given over to the sheriff's office, it still takes the sheriff a bit of time to come out to enforce it. It generally takes about 3 to 4 weeks for them to do so. The sheriff's office never has to communicate directly with the tenant exactly how much time they're going to have before they come out to enforce the eviction. But sometimes they will send the tenant a courtesy mailing that lets them know that they will be out soon to enforce the eviction. If a tenant does receive that notice from the sheriff's office that they'll be out soon, they can expect the sheriff within the coming days. Do keep in mind that even if an eviction order is entered with enforcement immediately, only the sheriff can enforce that eviction. So that does not give the landlord the right to come and remove property or change the locks or do anything to enforce the eviction without the assistance of the sheriff's office. Only the sheriff's office can enforce the eviction. Now, if for some reason an eviction order is entered against a tenant mistakenly, maybe the court dates got mixed up, maybe the tenant didn't attend court for some, miscalendering or other problem, then the tenant can file what's called a motion to vacate within 30 days of that default being entered. And what that does is asks the court to dismiss the or throw out the eviction order for now, stop the sheriff from enforcing the eviction, and instead have a proper trial in the case. In that motion, the tenant would need to explain to the court, why it is they missed their last court date or what the problem was that caused them to not get connected. A frequent problem we see is people didn't have adequate internet access and weren't able to get connected to the Zoom, so a default eviction order was entered against them. If someone suspects that that happens, they're going to want to get to file their motion to vacate as quickly as possible, either by getting in contact with a legal aid organization to help them do that, or by doing it themselves, using some of the tools that are out there like Renovention that Caitlin talked about earlier, because they only have 30 days to file that in order to get the eviction stopped. If it is after 30 days, the burden for stopping an eviction is much higher and much more difficult and would certainly require the assistance of an attorney. And additionally, because 30 days is already beyond that 3 to 4 weeks that it usually takes the sheriff's office to enforce the eviction, there's a very real risk that the sheriff's office will come out to enforce it before the time that the tenant has an opportunity to present any arguments to the court. So if a tenant does suspect they've been had a default eviction order entered against them, they'll want to make sure that they're addressing that with a motion to the court as quickly as possible. All right, now to talk a little bit more about sealing of the case. So sealing is something that tenants are usually very interested in when it comes to these eviction cases, because as soon as an eviction case is filed, it's added to the public court record, which can be reported by various credit reporting agencies. And that can make it difficult to find future housing. If you apply for an apartment and they run a background or credit check against the tenant, they may be able to see that that person has had a prior eviction case filed against them or is currently in eviction court. Additionally, some subsidized housing programs require that tenants not have had any prior evictions in order for them to be eligible for that program. And so, of course, if a prior eviction shows up, that may impact their ability to qualify for certain subsidized housing. So sealing is the process where you get the eviction case removed from the public court record so it's no longer showing up on background or credit checks and doesn't have an impact on future housing. Now, sealing is only mandatory in a very limited set of cases, and that's foreclosure-related evictions must be sealed at the time of filing. For all other cases, so that's going to be your, landlord-tenant cases where a landlord is trying to evict their tenant. The sealing is completely discretionary, which means it's up to the judge whether or not to seal the file. Tenants can sometimes make legal arguments for why the file must be sealed, but even if they are successful in arguing the file could be sealed, again, it's still up to the judge whether or not to do so. A tenant is not required to make a legal argument to ask for the file to be sealed. Lots of tenants who exercise their right to cure, which means they pay off the full balance of what's owed in a non-payment case, can ask for the file to be sealed, and many judges will still seal that file, even if the landlord doesn't want it to be sealed, or if they don't technically meet a legal standard that they should for getting the file sealed. Generally speaking, it's completely up to judges whether or not to seal these files. And so our advice to tenants is frequently to ask for sealing on the last court date, regardless of what the outcome is, because it never hurts to ask. And if the tenant did get the case resolved in some kind of way, like a move-out agreement, or they exercised their right to cure, or got rental assistance, something like that, their chances of getting it sealed are decent in front of some judges. There's also no time limit on sealing old cases. So if a tenant has had a prior eviction case where they got evicted, or maybe a default was entered after they moved out and they had no idea and a case was even filed against them, they can file what's called a motion to seal in that case. And that is a motion that would come before the court where the tenant would go in front of a judge, explained what happened and ask that the file be sealed. The tenant would maybe explain, the negative impacts that the case has been having on them, and try to get the court to seal the file. And again, it's always up to the judge whether or not to do so. And for some of those older cases, sometimes judges are more understanding, that if enough time has passed, they'd be willing to seal it. Evictions can stay on people's records for 7 to 10 years. So if an eviction from a couple of years back is impacting a tenant's ability to find new housing, then we generally recommend people try to file a motion to seal just to see if they can get the judge to remove that from their record. All right, another fact or fiction question here. The sheriff cannot evict a tenant during the winter months. And this one is unfortunately fiction. Excuse me, I'm getting a call. All right, sorry about that. So this one is unfortunately fiction. The sheriff can still come out to enforce an eviction, even when it's cold outside, even when it's below freezing, even when it's actively snowing outside. So some people assume that, if an eviction order is entered against them during the winter, the sheriff won't be out until the spring, and that is just not true. The sheriff will only hold off on enforcing eviction orders if they've been ordered to do so by the court, or if there is usually some kind of active weather emergency going on, that would prevent them from enforcing an eviction. But even if it's below freezing, even if it's snowing, they may still be out to enforce an eviction. All right. Now, that was a lot of information about what happens during court and the early resolution program. But one other resource that is available to some tenants who are going through eviction court is the Right to Counsel pilot project. This is a program that allows people to get additional representation beyond the one-time appointment of the early resolution program. So this would involve an attorney either helping them in some limited capacity, such as helping them try to negotiate a resolution or file a motion, or even fully representing them in court and attending all court dates on behalf of the tenant to try and present whatever defenses that they have. This pilot project is participated in by multiple different legal aid organizations. The Law Center for Better Housing is one of them, so that's our organization. Carpels and Legal Aid Chicago are also part of this program, and we frequently refer cases to each other, so that if a tenant has some kind of defense or issue that another organization believes needs additional assistance beyond what is available in the early resolution program, we have organizations that can help provide that. Now, this is not some kind of new agency. Like I said, this is a combination of different organizations all providing additional resources and services to tenants who are in eviction court. So that's to enables them to provide legal advice, negotiation services, and in some cases, representation. Unfortunately, these organizations do not have enough capacity or funding to be able to represent everybody who's in eviction court. So they can only represent a limited number of people based off the number of attorneys and capacity that they have at any given time. Most frequently, people who are in the early resolution program are going to be referred for more assistance if they have some kind of defense or need some kind of additional assistance in their case. If someone has been through the early resolution program and believes they have some kind of defense, they can always reach out to these organizations to seek free legal representation. But like I said, unfortunately, that does not guarantee representation to every tenant. As much as we really would like the program to do that, it's just not quite there yet. It's still in its kind of initial stages. So to be eligible for the pilot project, for the Law Center for Better Housing, we are generally only able to assist Chicago tenants at risk of homelessness or housing instability. There are limited cases where we can assist people who are in the suburbs, but funding and support for that is very limited. And so we are generally focused on Chicago tenancies. And as Caitlin said earlier, that's going to be market rate tenancies, not subsidized housing. For subsidized tenancies, I believe Legal Aid Chicago is the primary organization that assists people facing eviction from their subsidized housing. Now, another criteria is that the tenant must be at or below 80% of the area median income. So this is just a sliding scale that determines how much income somebody has based off the surrounding community area. Our services are generally limited to people who are lower income, lower middle income, and so only those people qualify for this. And then lastly, the pilot project, because it's partially funded by COVID funds, requires that there be some kind of COVID impact in order for people to get represented. Everybody had COVID impact because of increased prices, job losses, and things like that. So this criteria is not one that's pushed on very hard. And I believe as funding channels change, it's being less and less prioritized, if at all. But it is technically something that is supposed to apply to some of the programs that we have available because they're in part funded by COVID funds. An important note here is that none of these things are considering a tenant's or household member's citizenship or immigration status. So just because someone is here undocumented and is facing eviction, that does not mean that they are not entitled to free legal services. Just like everybody else is. They also don't have any different or less rights than someone who is a citizen or is documented facing eviction court. So if a tenant is facing eviction and they're undocumented and they're worried about that impacting their rights or their entitlements to different services, it does not. And so we don't want people to hold off on contacting us just because they're not documented. All right, now some additional considerations because, like I said, capacity is limited for this program. So attorneys will try to select cases based off of the meritorious defenses they have. It can be really difficult for an attorney to try and do anything useful in a case if there aren't any defenses happening in that case. So we generally try to prioritize those cases where there is some kind of defense that we could use to either prevent the enforcement of an eviction or kind of raise some counterclaims maybe a tenant has if they think it's retaliatory or if they have some other kind of problem that arose during the tenancy. Programs and the attorneys involved in them will also consider the tenant's vulnerabilities or situation in general. So if someone, had a really challenging circumstance come up that caused them to be in eviction court, maybe they're recently disabled, maybe they have, a lot of people living with them at the time, or their building is in a really horrid condition. All of these are different circumstances that can play into whether or not there's additional services that can be provided. And lastly, we always encourage people to remember that this pilot project is for eviction defense cases only. We get a lot of people who have other kinds of claims, maybe personal injury claims that they're interested in pursuing against the landlord. Those are not the kinds of things we can handle under this program and not the kind of counsel or representation that the Law Center for Better Housing can provide. We are only focused on, eviction defense and remedies that are available under the Residential Landlord Tenant Ordinance. For other kind of personal injury claims and stuff like that, we would not be able to represent people for those purposes. All right, so now this slide's a little outdated because the Right to Counsel program was renewed for another funding year. So fortunately, we don't have to attend this meeting from 2024 because it's already happened. But what I will say is if you do have any experience with the Right to Counsel program or the ERP program, and you're happy with the services you provided, we always encourage people to contact their local alderperson and community leaders, let them know the positive impact that these programs had on them, or if you're just generally interested in tenants' rights around the city and the surrounding suburban areas, let your community leaders and your local representatives know that you support the Right to Counsel program and you support the early resolution program for the services they provide to people. All right. And then lastly, we just want to close on one really important thing when it comes to the eviction process, and that is that the outcome is always going to be better for tenants if they go to court. A lot of the people we meet tell us that this is the first time they've ever been to court for anything in their life, and they're really scared. They're scared of the judge, they're scared of the process, they're scared of getting in trouble. And that's a very understandable and reasonable fear to have. But a lot of the free services that are available to tenants are only available to them if they attend their court dates. And attending court is going to be one of the best ways to get plugged into the different resources that are available in and around the city. That includes the free advice from attorneys, and then the possibility of reaching some kind of agreement, be that with the help of an attorney or through the mediation services that the early resolution program provides. Those kinds of agreements can get people more time to move and possibly a sealed record, like we talked about. And of course, going to court is going to be one of the best ways to get plugged in with a court-based rental assistance program. So if someone is facing a potential eviction, even if they think that there's really nothing to be done about their situation and they don't have any defenses, they should still attend all their court dates to get connected with all of these free resources. And if you want to get connected with the Law Center for Better Housing specifically, the best way to do that is going to be to call our main line at 312 347 7600. And when you call our main line, you'll usually leave us a voicemail just letting us know generally what your situation is, and one of our paralegals will call you back to do an intake and provide you with the appropriate service. So if you have some kind of situation that would require an attorney's assistance, they can refer that over to us. Again, we can't guarantee representation to everybody, so the most we can do is take each situation into consideration and make individual determinations. If they think that a tenant has a situation that would be more appropriate for the online chatbot or other limited services, we can generally provide that kind of brief advice or recommendations to people as well. So it never hurts to call if you are facing some kind of issue with your tenancy or facing a potential eviction case. And speaking of the chatbot, of course, you can go online to our website at lcbh.org and speak with that chatbot for rentervention, which can give you some free legal advice for situations that are especially good for if you have not yet received a termination notice or had a case filed against you. It's a great way to learn about what rights you have while you're still kind of in the middle of your tenancy, or if you think there's some kind of problem that's coming up on the horizon. And then last but not least, if someone does find themselves in eviction court and they want to get connected with the Law Center for Better Housing through the early resolution program, they can always request that they be referred to the Law Center for Better Housing when they are in the ERP program. So you would essentially go to your first court date, be connected with a case manager. The case manager would find a time for you to speak with an attorney, and you could let them know that you would like that attorney to be someone from the Law Center for Better Housing. And as long as you're not a subsidized tenant, they should be able to make that happen. All right, and we're just going to close out on a quote from Matthew Desmond's Evicted, Poverty, and Profit in the American City. Matthew says, "It is hard to argue that housing is not a fundamental human need. The reason is simple. Without stable shelter, everything else falls apart. We at LCBH believe housing is a human right, and we do a lot of work to try and defend and protect that right for everybody." So that's all the information that we have today. We'll open it up now for any questions people might have.
Well, thank you for that. Thanks, Eddie and Caitlin. That was a great presentation. A lot of good information in there. A lot to unpack as well. We'll go ahead and jump into the Q&A portion of the presentation. And I'll start off with the first question. And it is, what do I do if I get a notice of termination? Do I have to leave immediately?
Yeah, so this is a question that comes up often, and Eddie, if I miss anything, please fill in. But we generally advise tenants. I mean, it depends on the specific notice that they have received, but if you have received a 5-day notice, for example, that is claiming, a for-cause breach of the lease based on non-payment of rent, saying that you owe some amount of rent to your landlord within 5 days or you must leave the unit. That's not exactly true, right? If you're not able to pay the amount demanded in the 5-day notice, it doesn't necessarily mean that you need to get up and go. as we just walk through with the eviction process and, some of the tenants' rights in the local ordinance, there's a lot to consider and communicate with your landlord before, leaving the unit. And there's going to be a long process if the landlord does move forward with an eviction, filing an eviction and legal process that's going to proceed for possibly several months, right? So if you receive a 5-day notice and you don't have the ability to pay the amount demanded in the notice, speak with your landlord about potentially working out some sort of out of court, pre-court resolution. If not, if the landlord does move forward with filing a case, you will have many additional steps along the way to either work out a resolution with the landlord, get legal services, get rental assistance, something along that line. If it is a no cause notice, as we were sort of differentiating during the presentation, such as a 30, 60, or 120-day notice, ensure that you've been given the right type of notice first and foremost, and make sure that you have been given the right amount of time, either before a non-renewal or just a no-cause termination of your lease or a rent increase. And communicate with your landlord about the appropriate amount of time that you should have been given if you didn't receive the right notice period. But with no cause notices, those are going to be a little bit less negotiable or defensible. Certainly, you can always try to have a conversation with your landlord if 120 days you feel is not going to be enough for you to locate new housing. Be communicative with your landlord about that. Alternatively, if you have some sort of defense against the notice, if it was you believe retaliatory and you have really good documentation of that, you might be able to sort of negotiate with your landlord based on that. But otherwise, with the no cause notices specifically, those are going to be a little bit less defensible or negotiable, and you may have to end up leaving at the end of the notice period if it is 120 days or 60 days, 30 days, whatever it is.
Yeah, I think that's exactly right. And I just want to add, we, never advise people to make themselves homeless. So even if somebody receives a 120-day notice, for example, and they're unable to vacate by the end of that 120 days, there is still a strong possibility they'd be able to work out some kind of agreement with their landlord in court. And they are still entitled to free legal advice through the ERP program. So if someone does receive a notice and is worried they're not going to be able to be out in time and they don't have any other options, like I said, we don't recommend people make themselves homeless just to avoid an eviction case.
Thank you. So another question we had was, if your landlord is not making repairs to your apartment, are you able to withhold rent? What should you do in cases like that?
Yeah, so one of the slides that we talked about through the course of this presentation was the best next steps for exercising your rights under the ordinance if your landlord is not making repairs. And one of the things that comes up time and time again when we're working with renters is oftentimes people hear that if their landlord doesn't respond to a repair request, that they can withhold all of their rent for the next month or however many months until the issue is resolved. That is not exactly true. We do not recommend that people withhold an entire month's rent. And we do not recommend that people withhold rent without without following the required steps under the ordinance, which again is go through the normal channels first, whether it's your renter portal, calling your landlord, texting your landlord, emailing, whatever the course of conduct between the parties is. If the landlord's then unresponsive, follow your rights under the ordinance, which specifically say you can give written notice to the landlord, list the repairs that you are demanding to be made, wait the 14 days for the landlord to make the repairs. If the landlord does not then make the repairs within the 14 days, you do have options from there. And one of the options, along with terminating your tenancy and repair and deducting on your own, is withholding withholding an amount of your rent that reasonably reflects the reduced value of the premises. So there's no really hard and fast formula to say how much you should withhold. Again, we're always going to say be conservative, no more than half of your rent should be withheld. So I have had some tenants before sort of use like a percentage formula. If they experience a specific mold issue in their bathroom and they have only one bathroom in the unit and that is affecting their use of that space, kind of work out how many rooms are there in the building, what percentage of use does that reflect if you're unable to or you feel unsafe using that part of your unit, whether it's 10%, 5%, 25%. So that's kind of a tool that I've seen tenants use before to sort of estimate how much of their rent they should withhold. But again, just to hammer it home, always be conservative and no more than half. And the reason that we give that advice is because, first and foremost, we want your housing to be stabilized. We want you to be safely housed, and we want to avoid a position where you are potentially being terminated by your landlord for non payment of rent.
Great, great. Thank you for that answer. The next question is, do I have to be documented to access your services? Can my landlord threaten me with law enforcement if I am undocumented?
Yes, that's a good question. So there's no requirement that someone be documented for them to receive our services or to be provided free legal advice from the Early Resolution Program. It also does not change someone's rights under the Chicago Residential Landlord Tenant Ordinance. So just because someone is an undocumented doesn't mean they should be afraid to try and access the resources that are available to them and to seek help if they are facing potential eviction. As for can the landlord threaten them with law enforcement if they are undocumented? Unfortunately, there's little that can be done to prevent a landlord from reporting someone as potentially being undocumented. However, that conduct is potentially illegal in the context of a landlord-tenant relationship. There's been some limited cases where that kind of argument has been made, similar to kind of a retaliation argument that a landlord is not allowed to report a tenant as being undocumented if there's some kind of breakdown in the landlord-tenant relationship. However, if that person is reported, it's not necessarily that an enforcement agency could be prevented from acting on that report. Caitlin, do you have anything you want to add to that one?
No, I think you got it all.
Thank you. Can my landlord change my locks or remove my belongings if I am evicted?
So again, this would be an illegal lockout, which we talked about, is illegal under the ordinance. And again, that is prohibited for every rental unit in the city of Chicago. So no matter if your landlord lives in the building and if you have 6 or fewer units, the lockout provision is still going to apply. So a landlord cannot move forward with some of those self-help tactics, such as changing your locks and performing basically an illegal eviction without going through the court process. As Eddie made, super clear in the eviction process, the only person in the city of Chicago who can lawfully remove a tenant from their home is the sheriff. So if a case has not been filed and if it has not proceeded all the way through to the point of a trial, eviction order being entered, and that eviction order going to the sheriff, the landlord cannot change the locks themselves. And they cannot remove the tenant from the unit in that way. And so some of the steps, again, as a reminder that we walk through, are to first call the police, keep proof of your tenancy with you if you can, or on your phone, or easily accessible somewhere, in case that's something that you need to show to law enforcement. Get good documentation of everything that has happened and potentially an incident or a police report, and then finally potentially seek legal services, because that's something that a legal aid organization like ours may be able to step in and help. Eddie, anything that I miss?
No, I think that was a great answer. I just want to add that they also cannot remove your belongings even after you're evicted by the sheriff's office, after someone is evicted by the sheriff's office. For at least 7 days, the landlord's required to keep those belongings safe so that the tenant can come and reclaim them. And like I said, that's even after enforcement.
Great, great. One more question, and that is, can my landlord increase my rent? And are there any restrictions around this rent increase?
So I think the restrictions as far as rent increases go are kind of what Caitlin was talking about towards the beginning of the presentation. So that is the landlord needs to provide the tenant with at least 30, 60, or 120 days notice, depending on how long their tenancy is, before they're allowed to increase the rent. That being said, though, there are no kind of rent control laws in Illinois. And in fact, it may be very difficult to pass rent control laws because of the Illinois state constitution. So, in effect, that means that landlords can raise the rent. They can raise it by any amount, technically. Tenants could potentially argue that if they raise it by a very absurd amount, that that is a constructive eviction, so that they are being evicted by their landlord because of this rent increase. And that instead of doing that, the landlord needs to follow the proper eviction procedures. They may also be able to argue that a very excessive rent increase is retaliatory if they've participated in some kind of conduct. But for any kind of rent increase that isn't, a kind of really obscenely high rent increase, they're generally going to be seen as legal and permissible as long as the tenant was provided the right amount of notice.
No, great. Great answer, and thank you for that. I believe we are out of time. But there was a lot of great information there. I want to do a special thanks again to Caitlin and Eddie and the Law Center for Better Housing. Um, Thanks to all the guests who attended. We hope you're able to walk away with some good information. And if you want to be connected to Law Center for Better Housing, we are here to make that connection for you. Um, do understand these things can get complicated, and you probably have a ton of more questions. So we'll be happy to make that connection for you all. Um, and yeah, be on the lookout for our next Hub 101, and we'll be on the lookout for our next Hub 101. It will kind of be a blast out to all the things that are coming up, the fun events coming up this summer, and different resources that you'll be able to be connected to. Also, we'd love to see you out for our grand opening at the Aspire Center Juneteenth. Please save that date. And I think Zenobia wants to leave us with a little message as well.
Yeah. Like we mentioned earlier, the Hub is here to connect you to resources, even if something isn't the right fit for you. As the community resource coordinator, I work directly with the participants of the Hub. So I'll be following up with you if you requested additional Hub services in your registration form. I'll be following up to better understand what you're looking for so I can connect you with the resources or services you need.
Yes, and again, thank you. Hope to see you all again next month, and hope to see you all at the grand opening for the Aspire Center. And thanks again, Caitlin and Eddie. Great to have you on today.
Thanks so much for having us.
All right, until next
Thanks so
time.
much.